Next on the agenda, we have Mr. Todd Miller. He's the assigned to National Guard Bureau's Office of Chief Counsel as a senior counsel. He previously served in the same office as a litigation and employment law attorney, and previously with the U.S. Army JAG Corps as an attorney advisor, and served previously as an Army officer. Welcome, Mr. Miller.
Okay, thank you very much. Morning, everyone. How are you? Well, everybody awake? Got coffee? Admiral Hunter, how are you, man? I'm here today really to go over some legal considerations with the JCF program. I have 45 minutes ordinarily just teaching about the joint ethics regulation. It takes a good solid hour, and then you got to hang around for about another hour afterwards because there's all kinds of questions. But I don't really think you're concerned with that much of the JER. Really, we're going to try to focus on support to non-federal entities, which is kind of one portion of it. There's other parts that have to do with, say, gifts that you can receive from an NFE. You know, you can keep a ball cap or a coffee mug valued at $20 or less, and some other areas, but that's really not what your concern is. I think all the questions that I've heard so far at the conference had to do with how you can interact with NFEs, what types of support you can provide them, how you can participate with NFEs, and then in addition, how you collaborate with them. And I'm probably going to use that term about 15 or 20 times because something to always keep in your mind is that you can be designated by your command as an official liaison to an NFE. Now, there is the entire universe of NFEs, and there are some very special ones that have unique statutory authorities where they can get additional levels of government support that ordinary NFEs can't get. And we're going to talk about some of those, and we're also going to talk about how you could have an NFE that your organization has vetted, that you think is doing great things for service members and their families. You can have them added to the list of those few special NFEs that can get additional levels of support. But anyone in this room, assuming that you are a federally funded employee, can be appointed as an official liaison to an NFE. If you're actually a representative of an NFE or perhaps another federal agency, it's important for you to understand the limitations that really the Title 32 National Guard personnel are subject to, because everything they do when they interact with an NFE has to go through a vetting process with a state staff judge advocate, an SJA, who is an ethics counselor for the state. I'm an ethics counselor for the National Guard Bureau, but everything that happens within an individual state or territorial National Guard also must be vetted with the staff judge advocate and typically with a public affairs office for that state. Why? Because almost all of these questions, when we actually do the analysis, it comes down to whether or not there are mutually agreed goals, common interests between DoD and the NFE that will be furthered. And moreover, whether or not DoD's association with the NFE will portray it in a favorable light. And a little bit later, I'll give you one example where somebody in a certain western state made a command decision to provide a level of military support to an NFE that did not really portray DoD in a favorable light. But this is our roadmap for what we're going to try to cover in the brief time we have together. The basic ethical principles, if you're a member of another federal agency, the Corporation for National Community Service, if you're with HUD, if you're with DoD, you're all subject to the federal rules. These originated with President Carter's executive order back in the late 70s, and he directed the Office of Government Ethics to come up with very detailed guidance as to what federal employees can and cannot do when they are performing their duties, to include interacting with NFEs. And as you can see, there's a lot more to it than just support and interaction with NFEs. And then down at the bottom we have the Air Force and the Army values, which dovetail very closely with the ethical principles for members of the executive branch. Office of Government Ethics then put out through the Federal Register very detailed guidance. So this is kind of the parent authority for the DoD Joint Ethics Regulation. If you work for any other federal agency, you're subject to these rules too. But for people in DOD, like everything else, once it gets down to the DOD level, there's never a simplification. We don't just simply incorporate by reference some other part. We have to put our own unique spin on it. And then oftentimes the services will put a blue or a green or spin on it as well. The good news here is that it all stops with the DOD Standards of Conduct Office. They have a rules committee that determines what goes into the Joint Ethics Regulation. So if in your state National Guard you think DOD got it wrong, and when I show you the next slide, you may think that's true as to who is a DOD employee for purposes of the Joint Ethics Regulation. But there is a way where you vet it within your state, you send it up through your Adjutant General to NGB. It then goes up to the DOD Standards of Conduct Office. They have a committee that meets periodically and determines whether or not the Joint Ethics Regulations should be changed or not. And there's one right now that's currently being debated as to applicability to National Guard general officers when they are not clearly, say, in a Title 32 federally funded duty status. It's generating a great deal of interest. But as things stand currently, I just want you to really look down here. That's up top. We have Title 10 military personnel. That means you're on active duty. You're subject to federal command authority and funding. We have Title 5 civilians. If you work for CNCS, you're a Title 5 civilian. I'm a Title 5 civilian. National Guard technicians are Title 32 civilian employees of DOD. Do we have technicians in this group? Wow. Okay. Well, no technician jokes. No, I'm just kidding. I spent three years doing litigation for the National Guard Bureau Litigation Division, and almost every one of those cases involved technician matters. And if you want to watch somebody's head spin around backwards like Linda Blair's, try to tell a federal judge what a military technician is. Half federal, half state, half military, half civilian. Enshrined in law since 1968. You might not like it, but Congress created this program, and they're here to stay. So they are very unique. Fortunately, for purposes of the JER, they're pretty much just like everybody else, just like a Title V civilian employee. But then down at the bottom, we have National Guard members in a Title 32 duty status, or that final catch-all, or while engaged in any activity related to the performance of such duties or functions. That's pretty expansive. Your adjutants general, how often do they serve in a Title 10 or a Title 32 duty status? Sometimes. If they flew up here to Camp Dawson for the Guard Senior Leadership Conference earlier this week, they were probably on federal military orders, federally funded. But most of the time, who pays their salary? Who do they work for? Yeah, they're state cabinet officials. They are state agency officials. However, there's a provision in Title 32 that essentially says they are subject to follow federal military regulations. DOD's interpretation of both the Army and Air Force General Counsel's Office are that adjutants general, as well as other Guard general officers, if there is a nexus between the officer's National Guard of the United States membership and some violation of federal law, state law, or the Joint Ethics Regulation, they think the Inspector Generals for the services do have authority to investigate, and if they substantiate misconduct, to administratively discipline those officers, even if they were not in a federally funded duty status. So, again, the application is fairly expansive. Okay, finally, some of the concepts contained in the Principles of Ethical Conduct, and the JER are also criminal in nature, and these have to do with conflicts of interest, where someone misuses their official position for personal gain. I will give you one recent example because it involves a member of the National Guard Bureau, recently retired and recently indicted by the Department of Justice. This gentleman, by all accounts, was an exemplary National Guard officer. I know personally that he worked some of the hardest issues confronting the National Guard, and he served as an excellent spokesman for the National Guard before Congress, before state legislative hearings. he would be the last officer in the world that I would have ever suspected of violating the JER, let alone Title 18 of the U.S. Code for the conflict of interest provisions. But this gentleman, last month, and I have the whole indictment, actually it's the stipulation of fact. After you're indicted, if you get caught red-handed and do the right thing and come clean, you plead guilty and you sign with your attorney a stipulation of fact that says, yes, I am knowingly pleading guilty. I did the following. And this is what Colonel Porter said he did. This is the first page of his stipulation. First, while he was in uniform and he exercised contracting-related authorities, he steered contracts to a DoD contractor and gave them an unfair competitive advantage to the tune of $5.5 million worth of contracts. Did he get that much money? No. Did the contractor? Yes. Did they profit that much? No. Their profit margin is actually fairly narrow, as it is with most private businesses. Their profit, after they paid him his bribe, was $90,000. He, after he retired from military service, received a check for $55,000 from the contractor. The FBI is not that stupid. They're pretty good at following money trails of sophisticated drug and weapons traffickers and all that good kind of stuff. So it was pretty easy for them to find the paper trail here. So that's one thing he did. And the second thing he did is after he retired, he went to work for a DoD contractor. And he saw how effective this way was of essentially putting your thumb on the scale of what otherwise should be a fair competition amongst contractors for federal military business. And he approached a non-commissioned officer who worked for the National Guard Bureau with a bribe. Now, the bribe consisted of Redskins tickets, which you may not think has much value whatsoever, depending on your team affiliation. The last group had a big Skins fan who got pretty irate, but they were skybox tickets. And FBI said that they were valued at $1,200, and that's what he pled guilty to. So he not only accepted bribes, he bribed others after he retired from military office. So I just give you that as an example of an extreme case of a violation of the basic ethics principles, misuse of official position for personal gain. Okay, now let's talk about relationships with non-federal entities. Really, in the limited time we have, we'll discuss the general rules that apply as to support and the types of official participation that you can have and collaborations with NFEs. And then I want to tell you about some essentially special authorities that some NFEs get. If they're properly vetted, they can either be added to a list of approved NFEs who get enhanced support where they're recognized in statute, or the Assistant Secretary of Defense for Reserve Affairs can also acknowledge NFEs where there is shared, mutually agreed goals between DoD or a state guard organization and the NFE. And that allows for heightened levels of support, and perhaps even more importantly is every time there is a request to support an NFE or perhaps to interact, there has to be this vetting that goes through with an SJA and oftentimes with public affairs. Much of the JER analysis is centered on vetting the organization. So if it's, Billy Joe Jim Bob's blood bank that's been around for 3 weeks, well, maybe we don't want them providing blood to service members. If it's an organization that has a long and accomplished track record, they filed all the appropriate IRS tax documents, et cetera, and we have a shared community of interests, there's a good chance that they could be added to this list. And so then each and every time we go through and there's a support request or they want a speaker to come and somebody's going to talk about psychological health or military transportation, where we have something called innovative readiness training, where we're going to be training anyways. It's possible for an NFE to actually be a beneficiary of that if there is a training benefit for the National Guard. But if we go through this in advance, we've already vetted them. And what we've said is that there are shared interests, so that the hardest part is already done. We know who they are. We know that our association with them portrays DoD in a favorable light. Okay, I'll give you one more example. This one does pertain to NFEs. Oops, sorry. Well, let's do this first. What is an NFE? and this is actually an underhand pitch. It's exactly what the name implies, a non-federal entity. The only thing that's tricky about it is that an entity can be either a person or an organization. Person or an organization, non-federal entity. How about the National Corporation for Community Service? Is that an NFE? No. It's a federal corporation. It is a federal entity. So that one's easy. How about the West Virginia Military Department? Well, that's a little bit harder. Absolutely. It's a state. Remember, much like a National Guard technician is kind of a dual status technician, is half civilian, half military. Although they always look the same because Congress said they have to wear their uniform all the time, even when they're civilians. A state National Guard organization, just like the Adjutant General, who is an entity, his organization has two aspects. One piece of the state organization is purely state in nature. Are there any people here who are state military department employees? Purely state employees? One? Okay, outstanding. And many states, military departments, have attorneys who are also purely state military department employees. For example, we have some issues right now going on in the state of Alaska. It gets to a certain point where we're really not talking about federal law or federal military regulations. At a certain point, what is most important to an adjutant general are questions of purely state law. Can an officer be fired? Can their commission be revoked purely under state law? Well, could a federal judge advocate or an attorney at the National Guard Bureau answer that question? No. I'm not licensed in Alaska, and even if I was, I couldn't dispense advice on Alaska law. So under those circumstances, the state military department either has their own attorney or they go to the state attorney general's office to get their advice. So just one thing to keep in mind, although just like with the NFEs, we certainly have commonality of interest. And with the state military department, they often work side by side with federally funded personnel, whether they're technicians or active guard reserves. Everybody's working side by side. They have a common purpose. But when you're looking at doing an analysis on an organization, you always have to look at the organizational entity and look at each employee that you're talking about, just so that we make sure the rules are straight. Now, as a state military department employee, is that person subject to the joint ethics regulation that applies to DoD employees by that definition on the previous page? No. The federal equipment, say, for example, federal aircraft, Army helicopters, sitting out here at Camp Dawson. If a state military department employee said, sure, you can take that thing and fly it back to D.C., that'll save you several hours. That employee wouldn't violate the joint ethics regulation, but the joint ethics regulation would be violated because the equipment itself it's federal equipment. It's subject to federal usage requirements. It's not the state employee who would be held liable. It would be the adjutant general or probably a military officer who's responsible for the equipment. Down at the bottom, you can see some of the limitations. Really, what I want you to take away with is to be aware of the limitations, but also to know what the potential is, not only under the JER, but under some of these enhanced authorities as well. Like I said, anyone in this room who works for a state National Guard can be appointed as an official liaison to an NFE, provided your chain of command says that this is in the interest of your organization. You can speak in an official capacity, or you can actually sit on all of their meetings and be a participant, essentially serve as a member. You are a DoD representative to those organizations. Now, can you speak your personal opinion? Can you say it'd be a great idea if DoD would do this, that, and the other and put your name up in lights and endorse your organization? Well, no, you can't do that. But can you tell them what's of interest to your command, to your service members, to their families, to veterans of your organization, about the pillars of JCF, education, wellness, employment? Can you tell them about those goals and interests and see if perhaps they share some of them and if there's commonality of interest? Absolutely. And I've been asked several questions about interacting. Can we actually go out and solicit? Can you ask a particular NFE to come in and provide X, Y, and Z services at your installation while soldiers are on official time? Well, probably no. However, can you sit down at a table with them and collaborate and say we have certain limitations that service members get medical care while they're on active duty, and then when they're released from active duty, there's a transition period, and then after that, there is a delta, somewhat of a lack. So here are the areas where there are needs that we do not believe are currently being served by federal dollars. And then if one particular NFE says, well, we're actually currently administering a grant through the National Corporation for Community Service, and it does the following things. And we think some of your service members or their families may be eligible for these services. That's a collaboration. Now, what we don't have is DoD asking for things. Okay, give an example. Water. Here at Camp Dawson, let's say there's this factory up the river dumps some stuff in it, and we can't drink the drinking water, and now we're short on water. Can we call the local Culligan water distributor and say, hey, what we really need is 500 gallons of water so we can complete this great JCF conference that we're doing? We can't do that. What if we have, however, soldiers living all around this military installation? Their wells are contaminated. They can't drink water. Can we collaborate and say we have a need? We have 120 families, 365 total household occupants, service members and their families, that now do not have potable drinking water. This is a dire concern for the leadership at Camp Dawson. And then if the local Culligan distributor wants to step up and fill that delta and provide goods and services directly to those service members, we have successfully collaborated. So I think that's kind of what we're talking about when the speaker from Georgia had her kind of 1,000 points of light up on the screen. To the service member, it's seamless. If it's Uncle Sam providing the benefit, if he's getting it from his chain of command or USDA or from a local company or community organization, it really matters not. We just want to make sure that the need is being satisfied, and we do that through collaboration. Again, as an official liaison, as a participant at meetings, and then also there are levels of logistical support we can provide. Now, the one thing to be aware of there, and somebody in the previous class gave an example of gift donation boxes for holiday presents at an installation. NFEs can come on to military property and do certain things. As a general, they can't fundraise. That's one thing they can't do. But if they want to gather gifts to provide to impoverished children in the local area, to include lower enlisted service members' children, we might say that there is a community interest that's being served there, and we might let them come in and set up these collection boxes. We're not endorsing them. We're not telling people to make sure that they put stuff in the boxes or to give them money or to join the organization. We're just allowing them to operate on a military installation. But when we do that, we open the door. Because if you do it for one NFE, you're supposed to do it for all similarly situated NFEs. The key there, I believe, and you can discuss this with your SJAs, is similarly situated. When you describe the community interest that's being served by that NFE, you want to be very specific, so that the next time an NFE comes along and asks to do something similar, you say, well, we approve that because they're giving out gifts to impoverished children, and we have X population of our personnel who would be eligible for such gifts. A DoD interest is served by that NFE's operating on our installation. So you want to be as specific as you can when you vet the organizations. And a little later, we're going to talk about public-private partnerships. Those are important because, again, that's the vetting piece. We've already identified mutually agreed goals between DoD and the NFE. That makes them a little bit special. And I'm going to talk about some of the other special authorities. This is one example. I hate to give it because it's kind of crude, and that is a model driving I think a self-propelled howitzer. This is happening right now, and is under investigation. Just an example of a misuse of government resources, support to an NFE when DOD is not portrayed in a favorable light. This is a British calendar company that somehow talked a representative, I think, of a special forces group in a great western state into letting them come on to what is supposed to be a highly secure, like Camp Dawson, an installation where the special forces operate and train, and then they got to drive some of the equipment, and I'm told fire some of the small arms, et cetera, et cetera. So that would be an example of what not to do with government equipment, and it certainly portrays DOD in a bad light. And the Adjutant General of that state, one of his attorneys works for me at the National Guard Bureau, just sent me an email that the Adjutant General sent out, and it was like 2 to 3 pages long and absolutely scathing, and said in no uncertain terms, if you think this is funny, you don't have a place in my state's National Guard, and I will help show you to the door. So, again, another extreme example, but just kind of to drive home the point. Okay, some of the special authorities. This one, I think, just offers fantastic opportunity to the Title 32 National Guard. Like much of Title 32, a lot of the statutes are pretty old. Some of them almost 100 years old now, and really haven't been changed at all in that time. This one's not that old, fairly recent. But you can see the list of NFEs. These are kind of the old school NFEs that I think have probably been around for maybe 50 years or more. But I want to draw your attention to the very last one. That's a catch-all. It says that more organizations can get this enhanced NFE support up top: ground transportation, administrative support, communication support, EMT services, all those great types of things, if they're added to the list. Now, do we have to go back to Congress to add an NFE to this list? No, we do not. We only have to go to the Assistant Secretary of Defense for Reserve Affairs, who I believe the acting right now is a Mr. Whiteman. He was a former National Guardsman, served in all 3 components of the Army during a 41 career, and he works for the Undersecretary of Defense for Personnel and Readiness, who is a Miss Jessica Wright, who is the former Adjutant General of Pennsylvania. So these are people who are familiar with National Guard matters. I've been working in the Pentagon for 11 years. Senior leadership changes. Some are very savvy and smart on National Guard issues. Others, the eyes gloss over in about 15 minutes, and it's tough. It's tough communicating the interests of a population that is not on active duty at all times. A lot of the benefits and entitlements that they assume that all service members and their families have just simply don't exist for Guardsmen and their families. So this is one way to get enhanced support authorities. These are some other ones in Title 10, not as relevant, but there are some possibilities there. The directive on top has to do with innovative readiness training. This implements one of those Title 10 provisions, and it applies to the Title 32 National Guard as well. It's called innovative readiness training, thinking outside the box, finding ways to serve community interest at the same time we train. I used to live in Colorado Springs, worked at Fort Carson, had a little tiny house, but it looked right up at Cheyenne Mountain, and I could even see Pikes Peak from my backyard. And every now and again, a Colorado National Guard Chinook helicopter would take off and go up to the top of Pikes Peak or rescue somebody off the side, because forever folks were going up there and getting in trouble, and the Chinook was the only helicopter that could go up that high. And land or actually do a recovery operation on the mountain. And they were going to get rid of that aircraft a long time ago. But because of state pressure, it is still, I believe, to this day, in the inventory. Those operations were done under innovative readiness training. Does it matter if our troops are going to fly a helicopter from here, say over to Andrews Air Force Base and back, or if they go over to the Dolly Sods in West Virginia and rescue some snowbound hikers? It really doesn't. The training time is the same. Provided we can articulate a training benefit, that's another way that we can interact with NFEs and serve the local community. And the final thing, that I want to leave you with is a Deputy Secretary of Defense memo that also speaks about really enhancing relationships, enhancing collaboration, and potentially adding more statutory authorities so that DoD and DoD organizations can interact with NFEs. This one was signed a little while back now, April 2013, but I have several excerpts verbatim, which you're not supposed to do in slide presentations, but I thought the language was very powerful and really synchronizes perfectly with JCF. And again, as General Grass said yesterday, this is a concept that's moving from initiative to an actual program. And what I'm trying to do is identify some of the tools to really make it an institutional program and not just be something that the good idea fairy dropped in your laps, and give you the authorities and the tools that you need to actually make it happen. But you can see it's saying that it's encouraging use of public-private partnerships by DoD components to facilitate innovation and creative thinking. Again, even in April 13, we knew that the budget was going down within DoD, and we know that needs are still going to be there, especially for those for previously mobilized service members and their families, and the level of interest in providing for them may decrease the farther we move away from our periods of combat. So this is a way to enhance collaboration and essentially to use the existing rules under the JER and establish these collaborative relationships, again, where there are mutually agreed goals. And again, I can't emphasize enough, the purpose is to have our people interact in an official capacity, identify what the official position is of your units, your commands, and notify as to what requirements are that currently are not being served. And if we have vetted these organizations, then it makes it possible that we can interact and provide support to them on a much more frequent basis. And then a final item, down at the very bottom, I showed you one statute that there's a policy mechanism to add additional NFEs to so that we can have enhanced levels of support. This would be a separate statutory mechanism. And what Mr. Works is saying is that essentially if we try to use all of the other authorities that are currently out there, either under the Joint Ethics Regulation, under some of these other unique enhanced statutory authorities, under a public-private partnership, and we still can't accomplish what we want to accomplish with an NFE, legislation can be proposed. And that would go up through the state J1, J9s, through your SJs, through your Adjutants General, through the NGB J1 Programs Office, and on up to this office on top, which probably has an acronym, but I wouldn't know how to say it if it did. Office of Deputy Assistant Secretary of Defense for Homeland Defense, Strategy and Force Planning. Does anyone happen to know who that individual is? He is the former Adjutant General of Texas, Mr. Jose Mayorga. Also someone very familiar with National Guard matters and National Guard concerns. So I think these are opportunities. They are somewhat dormant authorities that aren't being fully exploited, but I think they do offer some possibilities to help bring JCF from a great idea, from an initiative, to a fully operational program. And with that, in my remaining time, are there any questions?
On one of the slides with the youth and the organizations that you had listed, you
Yes.
had the 4-H club cited.
I did. Oh, I'm sorry. I did because there was a signing ceremony yesterday at the end of the day with 4-H.
Oh.
That was the only one that I thought explicitly related to JCF. And I actually didn't get to attend the presentation, but my understanding is that USDA has a presence in almost every county in the United States. So it was really viewed as an excellent example and really thinking outside the box. There are some other NFEs, the Veterans Farmer Coalition and Homegrown by Heroes are two that I really like, that I don't endorse officially, but personally I really like. That's doing great thing for veterans employment.
Does this mean that you can endorse these?
No, what it means is you can do these additional things for them. Now, as far as endorsing, like endorsing that goes towards fundraising, a gentleman in my previous class asked that question about CFC. For CFC, this list of Title 10 statutory authorities, there is a separate statute for CFC that says people in a federally funded duty status can not only endorse them, they can encourage service members to participate, and they can allow them to fundraise. They can have bake sales and military installations, et cetera, et cetera. So they're somewhat special. Yeah. Now, remember, endorsing, again, talk to your staff judge advocates and your public affairs people. It's one thing to acknowledge an NFE for what they do, to actually say what they've done in your community. Culligan Water distributed 500 gallons of drinking water to National Guard soldiers in eastern West Virginia during the latest water contamination crisis. That's just simply stating a fact. That's not an endorsement. Now, if you say everyone needs to get out there and attend their fundraising presentation and dig deep in your pockets, or back in the day when I came in the Army, there was a certain non-federal entity that operated on Fort Benning where you were actually signed in as part of your in-processing, whether you wanted to or not. They even gave you a credit card in the name of the NFE, whether you wanted to or not. You could opt out 6 months later, but by golly, you're going to support them for 6 months. Well, that's how things used to be. They're not. That was actually before the JER came out. So,
I have a question.
yes, ma'am.
On your very first list, you had spouse clubs.
Yes.
Okay, so I guess I'm confused. So there.
As an NFE?
Yes.
Yes.
So if the spouse club from our wing
Okay.
wanted to do a bake sale, are you saying that's allowed? That's not allowed, or is that like it has?
Yes. When you have an NFE operating on a military installation, and this is where, if we were in the longer JER class, we could drill down a bit. There are general rules that apply to NFEs operating on military installations, and then there are more specific rules that pertain to those NFEs whose membership is comprised primarily of service members and their families that provide services, events, entertainment, etc., only of interest to that limited military community. They can fundraise if approved by the installation commander. They're not endorsed or anything by the command, but they're allowed to operate, to hold a bake sale, to sell hot dogs, etc.
Are they allowed to, if it's the spouse group of our wing, but they're allowing all military spouses to belong to it? Does that open it up to a different level?
Like a mega spouses group. Okay. I don't want to shoot from the hip. I would.
But I'm just saying, because we're in an area where it's a small installation, so our spouse group is opening it up to the Navy and Army National Guard and everybody.
Again, the SJ would have to review it on behalf of the commander, but I would say that's still a limited military community that the larger group would pertain to, and I believe most likely they would still be allowed to. Again, this is purely discretionary. Purely discretionary. The commander may. And again, it comes down to what I do for one, I may have to do for others. And I'm not aware of an example where a spousal group's request to do things compromise the military mission. But let's say there's a heightened security level on the base, and they just don't want that many people coming on and off post. There might be some operational considerations, but as a general rule, no, I don't think that would be a problem. Anything else? One more, ma'am? Okay.
Well, I just had a situation where I sent out an email about a homeless shelter that was having a walk,
Right.
fundraising to help veteran housing.
Okay.
And I got my hand slapped for sending that.
Okay. When you're doing announcements, you are using government resources, whether it's an email or private snuffies making a poster and sticking it up in the hallway or something like that. As a general rule there, if there is an interest served, essentially a DOD interest, something that the community event furthers an interest of your service members, it can be announced, but no further. That's no endorsement. That's not encouraging people to participate. That's not saying, the 1st Battalion already has 50 people who are participating. What's 2nd Battalion going to do to answer the call? Anything like that. And you don't want it coming typically from a senior leader, because that sometimes implies an official endorsement. And that your point of contact, if there is a point of contact for the event, should not be someone's official, federally funded telephone or email account. It should be somebody who participates in a personal capacity or a representative of the NFE downtown.
Even if
That
it's
helps.
to benefit veteran housing.
Yeah, again, I mean, that would be the thing. You'd have to do the analysis to say there is a community, a DoD community purpose served. That gets you in the door. But there are just certain things you have to be careful of as to how you phrase the announcement.
A line saying that you don't endorse.
You don't have to do a disclaimer. You don't have to, but there are times when a disclaimer is required. Yes, ma'am.
I was going to ask you,
Uh-huh.
put a disclaimer on it.
Right. Yeah, that would be an example. Sometimes when we have official speakers at events, they go and they state the official position. If we have someone who's authorized to go in a personal capacity and they're speaking purely based on their personal opinion, they may be allowed to go in uniform, but then they would have to give a disclaimer. And also sometimes when we have people publish, they can identify themselves, say as a military officer, but they don't use their title essentially as an endorsement. Read my book because I'm the Vice Chief of the National Guard Bureau and I'm a great guy. That would be bad. That would be bad. So we still want to keep that distinction when necessary so we don't imply an improper endorsement like to the British Calendar Company. Okay, I think that's all the time we have. We have another speaker. I'll stand by outside if there are any further questions. Thank you very much.